taxes on the
I
camera. I
need
said,
to
"What
go
is
get
this?"
more.
You're gonna lower this and raise
That's
it.
right. It doesn't
I'll be right back.
That's exactly right.
You did. I was sat there for hours.
Did you get somebody give you a ride?
No, I
We
didn't want.
did it because it was 18.5%.
Did you go to truck?
Senate will please come to order. We don't have a lawnmower today, so we'll have a moment of silence. That will be nice and silent. Thank you. Are there any announcements? Senator from Chittenden.
Thank you, Mr. President. I move that Senate Rule 31 be suspended and that H 585, an act relating to amending the pension system for sheriffs and certain deputy sheriffs, not be referred to the Committee on Appropriations.
Now, the senator from Chittenden Central has moved that the Senate suspend its rules and that Senate Rule 31 be suspended and that H 585, an act relating to amending the pension system for sheriffs and certain deputy sheriffs, not be referred to the Committee on Appropriations. Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have suspended your rules and allowed that H 585 remain on the calendar for notice as opposed to being referred to the Committee on Appropriations. Senator from Bennington. You appear muted. We're going to fix that. Whoops, now we've taken you off the screen. Can you make him back to video? There you are. Keep talking. I think we'll get you.
Okay, I move that the rules be suspended and the Committee on Appropriations will be relieved in May 702 and activate the legislative operations and government accountability. And it will be committed to the Committee on Judiciary with the report of the Committee on Government Operations.
Now, the senator from Bennington has moved that the rules be suspended and that the Committee on Appropriations be relieved of H 702, which is an act relating to legislative operations and government accountability, and that the bill be committed to the Committee on Judiciary with the report of the Committee of Government Operations intact. Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have suspended your rules and relieve the Committee on Appropriations of H 702 and refer to the Committee on Judiciary with the report of the Committee of Government Operations intact. That brings us to a few bills for reference here. The first being H 885, appearing on the calendar for notice, affecting the revenues of the state, will be referred to the Committee on Finance. H 55, affecting the expenditures of the state, will be referred to the Committee on Appropriations. H 233, affecting the expenditures of the state, will be referred to the Committee on Appropriations. H 622, affecting the expenditures of the state, will be referred to the Committee on Appropriations. And H 873, affecting the expenditures of the state, will be referred to the Committee on Appropriations. We now have another bill for reference under Rule 44A. I don't know, did it get voted out of rules? The Rules Committee has released H 888, and it is referred to the Committee on Government Operations. That brings us to the orders of the day. And my understanding is we will actually start at the beginning of the calendar today. And so you'll find on page 4206, Bill H121. H121 was read for the first time, referred to Committee on Economic Development, Housing, and General Affairs, where the committee recommends that the bill be amended, and once amended, that the bill ought to pass. The bill was then referred to Committee on Appropriations, which also considered that when amended, the bill ought to pass. Please listen to the second reading of the bill.
H121, an act relating to enhancing consumer privacy.
Now you've heard the second reading of the bill. For the report of the Committee on Economic Development, Housing, and General Affairs, the Senator from Chittenden Southeast.
Thank you, Mr. President. I imagine we all have at least some understanding that our digital interactions, behaviors, and choices are highly valuable in the marketplace of information and targeted advertising, and that often our devices know more about us than we know about ourselves. Sometimes it is happening so seamlessly in the background of our daily interactions that we consider it a convenience or enhancement when our choices and preferences are saved and reflected back to us. And sometimes it presents us with a stark and dystopic feeling of being watched and manipulated by invisible profit-driven forces. We are left with growing suspicions and conflicting feelings that our behavior, spending decisions, and placement of our attention are, in essence, the products themselves. We had this discussion in very stark, principled terms earlier in the session when it came to the kids code. We voted unanimously to ensure our children are protected from these manipulative forces and do not have their data bought and sold before they are old enough to consent to these kinds of transactive choices. It very specifically applied to the proverbial big tech players, the largest social media companies in Silicon Valley. Vermont has also led on the larger conversation of the purchase and sale of data with its groundbreaking data broker regulation that lays the foundation for this bill. For over 5 years, we have required those who control and process data to register with the state and acknowledge consumer privacy and protection, something that more states are beginning to do now. We now come to you with a companion data privacy bill that delves more deeply into the complexities and trade-offs of using data as a means to move freely in a global marketplace, while ensuring we experience protection and agency as consumers. Passage of this bill would give us one of the strongest data privacy laws in the country, setting the lowest consumer threshold for applicability of any state, and building on new laws in other states like regulating information deletion and biometric data. But it would balance this with the need to guide and inform our small businesses, nonprofits, and health organizations on its provisions before exposing them to costly penalties or litigation for failure to comply. Generally, this bill grants Vermonters the following rights with respect to their personally identifiable data: confirmation and access, notice of third parties to which personal data has been transferred, correction, deletion, data portability, opt-out of targeted advertising, sale of personal data, and profiling, and requires data controllers to establish procedures to facilitate the exercise of those rights, including specific timelines and appeals process for any denial of these rights. This bill applies to a person or commercial entity conducting business in Vermont or producing products or services targeted to Vermonters, and during the preceding calendar year, either controlled or processed the personal data of at least 25,000 Vermonters, or derived more than 50% of their gross revenue from the sale of personal data. There are two types of exemptions to the provisions of this bill. First, data level exemptions for data covered by independent privacy regimes. This includes health-related information regulated under HIPAA and financial information regulated under the Gramm-Leach-Bliley Act that federally regulates consumer information used by financial institutions. This is further underscored by entity-level exemptions for financial institutions and insurance providers regulated by our Department of Financial Regulation, as well as for government and law enforcement entities. What obligations does this impose on controllers of data? Data controllers, essentially those who are directing the use and any transactions related to the data, must provide a privacy notice that sets out the purpose of the collection and processing, process personal data only as reasonably necessary and proportionate to achieve a disclosed purpose consistent with reasonable consumer expectations, establish data security practices, provide consumers a way to revoke consent to processing and to submit requests to exercise their rights, and obtain consent to process data for other purposes beyond those above, or process sensitive data at all, which is further defined in the bill. Additionally, a controller must take reasonable measures to ensure de-identified data cannot be associated with an individual and monitor compliance with contractual commitments for de-identified data. Processors, those who are operating at the direction of controllers, must adhere to the controller's instructions and assist the controller in meeting its obligations, and enter into a contract with the controller governing the processing, establishing a duty of confidentiality and requiring deletion or return of personal data at the controller's direction or the end of services. Vermonters' consumer health data is subject to additional protections, including a duty of confidentiality, no sale without consent, and prohibition on geofencing when accessing medical care. Because so much of the concern around data privacy and consumer protection in the context of recent events is related to healthcare access and health information, it was important to your Economic Development Committee that we give an adequate amount of time and deference to your Health and Welfare Committee to review these provisions. Finally, this bill increases the civil penalties for data brokers that fail to register their presence and activities and introduces civil penalties for omission of information or filing of materially incorrect information. I will now very briefly walk through some of the pertinent details in each section of the bill. Section 1 establishes a new chapter in Title IX, hereby entitled the Consumer Protection Act or the Vermont Data Privacy Act. Title IX, the Consumer Protection Act, known as the Vermont Data Privacy Act. This first section is definitions. This is where you will find the specific definitions of key concepts for this act, like consumers, controllers, personal data, which is information that can be linked to an identified individual Vermonter, processors, consumer health data, personal data that a controller uses to identify a consumer's physical or mental health conditions, subject to heightened protection, and sensitive data, including consumer health data, government identifiers, financial information, precise geolocation data, and the data of minors. Applicability, generally the act applies to a person that conducts business in Vermont or produces products targeted to Vermonters and meets the 2 thresholds mentioned earlier. Exemption from the act, as I said, applies to certain kinds of data and certain kinds of institutions in recognition of both independent privacy regimes and practical concerns about the way we conduct business online. There is next a section that spells out consumer personal data rights. It establishes the following 6 personal data rights and establishes a controller's responsibility for responding to a consumer's request to exercise any of these rights: confirmation and access, notice of third parties to whom personal data has been transferred, correction, deletion, data portability, and opt-out from targeted advertising, sale of personal data, and profiling that would be used to make certain significant decisions, such as someone's insurance coverage or things like that. I spelled out the duties of the controllers, which again in section 2419 imposes obligations that include a clear and accessible privacy notice that discloses the purposes for which a consumer's data is collected and processed, data minimization principles in processing personal data, data security practices, methods for consumers to revoke their consent, and a requirement to obtain consent to process sensitive data. The next section is the duties of controllers to minors, and we will see a proposal of amendment that would attach our previous kids code work to this bill. And so some of these sections will change so that we harmonize minor protections to be stronger than they were coming over to us in the original data privacy bill. But currently this requires that a controller offering any online service, product, or feature to a known minor use reasonable care to avoid heightened risk of harm. This does allow some instances of the process and sale of data to minors, and that is what we have changed in the kids code, where such commodification of children's data is prohibited. The next section, duties of the processors, task processors with assisting the controller in meeting the obligations under the act and establishing further data security protections. Similar to the last section, the section 2422, task processors with assisting the controller in meeting obligations to minors in offering an online service, product, or feature, which again will be harmonized. 2423 is the section on de-identified data. I think sometimes when we read headlines and we get concerned about how our information is bought and sold or shared for commercial purposes, we are looking at concerns about de-identified data, which is much harder to regulate than personally identifiable data. But this still requires that you maintain de-identified data in forms that protect the consumer's privacy, so it cannot be re-identified, let's say, as we often worry about in our tax policies. Section 2424 is the construction of duties of the controllers and processors. It clarifies how the act is to be construed, making clear that it will not limit certain ordinary course operations, such as businesses' ability to comply with laws and subpoenas, to cooperate with law enforcement, to carry out obligations under contracts with exempt state entities, and to provide products requested by consumers. This also permits businesses to collect and use data for internal purposes, such as research, repair, and product recall. 2425 is the section on enforcement. It gives sole authority to enforce the act to the Attorney General. The Attorney General may issue a notice of violation to permit a business to cure any violation if the AG determines a cure is possible. This section additionally tasks the AG with reporting annually on violations and cures under the Act. I will pause here and say the sole authority granted to the Attorney General here mirrors existing law in the data broker provisions of this bill that have been in existence for 5 years. So we have not had anything but the sole enforcement of the AG under the data broker section, which often relates to data breaches and other concerns about use or sale of data. Section 2426, consumer health data, prohibits persons subject to the Act from providing consumer health data to an employee or contractor without a duty of confidentiality. And it prohibits persons subject to the Act from providing consumer health data to a processor without a contract in place, prohibits them from using a geofence to establish a virtual boundary around a healthcare facility for the purpose of identifying or collecting data from a consumer, and it prohibits them from selling consumer health data without consent. Section 2 of the bill now looks at how to further address data privacy by amending our existing Artificial Intelligence Advisory Council. This was a recommendation of the Agency of Digital Services because they now have much more expertise in the Agency of Digital Services to look at consumer data privacy, to look at consumer protection, and to make recommendations back to the legislature. So this expands the Agency of Digital Services existing AI Council to address data privacy. And it makes it the Artificial Intelligence and Data Privacy Advisory Council. It tasks the expanded council with providing advice to the Attorney General in its enforcement capacity and developing policy recommendations, including for education and outreach, which currently isn't as robust in the bill as we would need it to be for people to fully understand their rights and responsibilities as leaders of businesses, nonprofits, or healthcare organizations, and to make recommendations on a future private right of action that is to be provided to the committees of jurisdiction on or before January 15th of 2025. Section 3 updates Vermont's existing data broker laws, which I've mentioned, to increase notice obligations and civil penalties for certain registration violations. In that definition section, we clean up a few references so that we match the terms in the Vermont Data Privacy Act. We expand the definition of consumer to include visitors to Vermont. We track a lot of data of visitors, and we want to make sure they experience protections and meet these thresholds as well. And it clarifies that disclosure of information a consumer made publicly available does not constitute a sale of data. The next section is the notice of data broker security breaches. Existing law requires disclosure only of security breaches affecting data collectors. This new section requires data brokers to notify consumers and the Attorney General of any data broker security breach. Enforcement is handled by the Attorney General's office, and for businesses licensed or registered with DFR by DFR. 2446 is the annual registration of data brokers. This has been in place, but this would raise the civil penalty for data broker failure to register with the state from $50 to $125 a day, and it creates liability for the omission of required registration information and for the filing of materially incorrect information. While the filing of materially incorrect information would be constituted as meaningfully misleading information by a data broker creates an immediate civil penalty, $25,000. Daily penalties for these new liabilities do not kick in until after 30 business days following notice of the problem. This is a new credentialing section in 2448 for data brokers. It requires data brokers to establish procedures to ensure brokered personal information is used for a legitimate and legal purpose, including requiring prospective users to certify their purposes. Finally, section 4 is the effective dates. The expansion of the AI Council to the AI and Data Privacy Council to address data privacy goes into effect July 1st of 2024. The Vermont Data Privacy Act and updates to the data broker laws go into effect July 1st, 2025. Mr. President, this is a responsible step forward to ensure Vermonters' consumer protection and data privacy while providing our regulated entities with the clarity and guidance needed to comply. Your Committee on Economic Development heard from Jessa Barnard of Vermont Medical Society, Planned Parenthood of Northern New England, Westport Hospitality, the Attorney General's Office, the Vermont Technology Alliance, the Vermont Law and Graduate School Center for Legal Innovation, as well as their small business legal clinic. the Vice President of Government Affairs for the National News and Media Alliance, our Legislative Council, the Vermont Association of Hospitals and Health Systems, the Secretary of State's Office, the Vermont Country Store, the Mid-State Auto Group of Vermont, Vermont Law and Graduate School, once again, the lead state senator on the data privacy legislation in Connecticut, the Common Good of Vermont, manager of policy and strategic initiatives housed in the United Way of Northwest Vermont, Vermont Gas Systems, the Connected Commerce Council, the reporter from the House, the Agency of Digital Services, Consumer Reports, Vermont Retail and Grocers Association, the Vermont Chamber of Commerce, and Blue Cross and Blue Shield of Vermont. Our vote out of committee was 5-0 to advance the bill, and we ask for your support.
Bill is then referred to the Committee on Appropriations, which consider the same for the report of the Committee on Appropriations, Senator from Washington.
Thank you, Mr. President. Your Committee on Appropriations reviewed the bill for any expenditures of state funds. There in the advisory council, there are 12 members. The 6 of them are employees of the state. And so we have the regular language in here that if you're an employee of the state or otherwise compensated, you wouldn't be able to get per diems or expenses. So the Appropriations Committee thought it would be de minimis amount of funding that would have to come from the state. And so we recommend that the pass in concurrence with the proposal amendment from the Committee on Economic Development, Housing and General Affairs.
So the question is, shall the Senate adopt the report of the Committee on Economic Development, Housing and General Affairs? Hold on just 1 second, please. We're not going to call a recess. We're just going to pause for half a second. The question is, shall the Senate adopt the report of the Committee on Economic Development, Housing and General Affairs? Are you ready for the question? Senator from Chittenden Southeast.
Mr. President, apologies if this is out of order. Our committee will also be bringing forth an amendment to, as I mentioned in my report, to attach the kids code to this bill. I just got a note from Legislative Council that that's not ready yet. So I am looking for guidance for what procedure we might engage in next.
So with respect to the point of information or inquiry for a moment, there will still be a third reading of the bill. So you've got this vote to potentially amend the bill with the report of the committee. Then there would be the vote to move it to third reading. And then prior to third reading would be another opportunity for amendments. So if those amendments could happen in any of that process, we could move forward now and come back to that later. Senator from Chittenden.
Thank you, Mr. President. I will offer to the body that it's the intention to do third reading tomorrow rather than today to allow, there are a number of people preparing amendments. My additional hope is that we will message our actions tomorrow to the House. So hopefully that way we allow time on the front end, but get rid of time on the back end. Thank you.
Senator from Chittenden Southeast.
Thank you, Mr. President. As was indicated by the presenter of the bill, Health and Welfare has worked on this bill, on the sections related to our jurisdiction. And we do have a proposed amendment. And so I was hoping to provide that amendment for second reading. As I look through the report that's in the calendar, there are significant pieces missing from what we would have in our amendment. And I am loath to wait until there's a second amendment coming out of the Economic and Development Committee. So I will have a proposed amendment and go through it with folks when it's ready. Thank you, Mr. President.
So my understanding is, due to some of the length of duration of this conversation itself, we may have enough copies of whatever it was that was handed in to have that opportunity. So the question right now is, shall the bill be amended as offered by, shall the Senate adopt the report of the Committee on Economic Development, Housing and General Affairs? Are you ready for the question? Senator from Addison.
I'm just wondering if we're going to be able to do the amendment that the senator from Chittenden South just mentioned, or is that going to be on third reading?
So the current question is, shall the Senate adopt the report of the Committee on Economic Development, Housing and General Affairs? When that is adopted, we will then have the question of, shall the bill be read a third time? At that time, amendments can still be offered. And I would imagine at this point, that amendment will be copied enough that if a senator were to want to offer that amendment, they could stand up and offer that amendment before we ordered the third reading of the bill today.
Okay, well, the reason I ask is because my vote on whether we adopt the committee's report is dependent on whether we adopt the amendment from the senior senator from Chittenden South. Southeast. South.
What I understand of the amendment, Senator Sears, you might want to mute your microphone. The amendment, as I've seen it, is an amendment to the bill. It is not an amendment to the report as drafted. So it appears as though the way it was drafted was to be after this vote anyway.
I see. Okay. Could I speak to the amendment?
That is the debate on the floor is,
Okay.
shall the Senate adopt the report of the Committee on Economic Development, Housing and General Affairs?
Okay. Thank you, Mr. President. As the senior senator from Chittenden Southeast said, the Committee on Health and Welfare did a significant amount of work on this bill, took a lot of testimony on the portions of the bill that are relevant to our committee of jurisdiction. And in doing so, learned a lot about the scope of the entire bill. And I am very uncomfortable with the amendments that were made by the Senate Economic Development Committee, and that they weaken the bill that came over to us from the other body pretty significantly. And I don't feel like they are giving consumers in Vermont who are subject to the whims and the economic incentives of large technology companies sufficient protection. This bill is supposed to be a consumer protection bill. It's supposed to protect Vermonters from having their data used incorrectly, inappropriately, for profit, and for nefarious purposes. And I believe that the bill as it came to us from the other body did a much better job of doing so than the bill as it came out of our Committee on Economic Development. And I therefore urge people not to support the report of the Committee on Economic Development. Thank you, Mr. President.
Senator from Chittenden Southeast.
Mr. President, if it will help clear the air, I would offer our proposal of amendment at this time so we can have a debate about that amendment as it relates to the report from the Economic Development Committee.
I believe the amendment that you are offering is being handed out. It is an amendment to the report. And Senator, you have the floor, so.
Thank you, Mr. President. So much of our personal data is related to healthcare, and it's very much related to how that healthcare data might be taken and used inappropriately. Last session, we worked very hard on a shield bill that would protect folks in the healthcare industry from use of data in inappropriate ways. And this, I believe we're offering a proposal at this time that will improve our efforts as they have happened in the past. So I have handed out, or the secretary's handed out on my behalf, our behalf, an amendment from 3 of the 5 members of your Senate Health and Welfare Committee. I will go through what's here very briefly and perhaps try to give you some reasons for what we have done. We did take a good deal of testimony from folks in the healthcare environment. We also took testimony from the Attorney General's office to understand penalties that might be applied when violations of the bill take place. So as you know, some of the work that's been done across the country, and in particular with respect to this bill, is very much related to what we have seen for folks who are seeking reproductive care and also for gender affirming care. And so when I visited with some other representatives and senators at the White House last June, we looked at what other states were doing, and that included the state of Washington. The bill that is posted on your Senate Health and Welfare Committee's board is a bill that we introduced representing or reflecting what the state of Washington has done. And as I understand it, the bill that came to us from the other body included healthcare work that's done in the state of Connecticut. Well, we're not either state, we're Vermont, so we've made some changes to the language in the bill as it relates to our understanding of healthcare related issues. And so if you look at the first proposal of amendment, you'll see that we're cleaning up a definition section. We're taking abortion out as a definition because it's already in Title IX and it seems superfluous to leave it in. Then we're also adding, aligning the definition of biometric data with the bill as it came to us from the other body to capture depictions, images, descriptions, or recordings. In the report that we have from your Senate Economic Development Committee, there is a biometric data that includes facial, hand mapping, geometry, and templates, but not data from photo, audio, video recordings. So it seems like that's kind of a conflict. We have one, not the other, and I don't know how we discriminate between the two. So our committee thought it more appropriate to include the photographic, audio, and video recordings as data that could be that we don't want to have used inappropriately. We also added, for purposes of a new exemption that we'll talk about later, we added definition for healthcare component. And this is used to refer to components of a covered entity that are not covered by HIPAA, and I'll explain that a little bit later. But as you know, HIPAA for us is the Health Insurance Portability and Accountability Act at the federal level, which has been so key to protecting our personal healthcare information. So we are adding a healthcare component piece, and we'll have a definition, which is a new definition for a hybrid entity, and that's a HIPAA covered entity for which only certain components are covered by HIPAA. This one is interesting. We know HIPAA covers healthcare. We think automatically of hospitals and doctors' offices and so on. But sometimes there's ambiguity. And what is that ambiguity? Ambiguity would be when a healthcare organization also provides other services. One of the examples that was brought up in committee is a hospital that is then building and collecting data, building housing perhaps for their staff, and then has data about the staff that would not be covered by HIPAA. Or another example might be thinking about what's happening globally to our healthcare world with our large corporate pharmacies that are now offering clinical services, but then they're also the general store. So those are hybrid entities that we want to be sure that we're protecting the healthcare data, but the data that might be picked up by over-the-counter stuff is open for discussion. So we added in hybrid entity. Then we've modified the definition of publicly available information to ensure that biometric data that is collected without a consumer's knowledge is not excluded from protection. So we can think about a photograph of someone going into a Planned Parenthood or a psychiatrist's office and how that photograph might be used erroneously. The second instance of amendment replaces the data level exemption for HIPAA protected with an entity level exemption for HIPAA regulated entities. In other words, it's covered by the federal law. So we want to protect those entities that have personal health care data. So we're exempting those things that are covered by HIPAA as a whole, or HIPAA regulated components of a hybrid entity. So if you've got the clinic, and then you have other things going on, other data being collected, the clinic is under HIPAA, that's exempt, and we're adding that exemption. And then HIPAA regulated parties acting on their behalf. So that would be the business associates who are under the controller or the HIPAA regulated organization. So that is the second instance of amendment. The third instance of amendment deletes language exempting information treated in the same manner as HIPAA protected health information, now that HIPAA entities receive an exemption. So we took out the language that doesn't relate. And then there's a little section in there about HIPAA data being protected, even if it's commingled with other data that's not HIPAA data. So the commingled data then would be also overseen as medical data, and so it would be overseen by HIPAA. The fourth instance of amendment adds protection under our under Title IX for the consumer protection, and this does include as an ultimate as a possible action a private right of action, which is currently in statute in Title IX. And the private right of action is available exclusively for violations under the section of protecting consumer health data and biometric data without consent, when it's used without consent, and also for the COPA coordinates for the children's protection. This section also includes confidentiality of consumer health data, including using geofencing. And this is critically important for areas where folks are entering sensitive clinics. The fifth instance of amendment is cleanup language to recognize mental health facilities and reproductive or sexual health facilities, that they are a kind of healthcare facility. We want to be sure to be inclusive in our language. And then the sixth instance of amendment expands the AI Data Privacy Council to include the Secretary of Human Services and tasks the council with developing policy recommendations for data privacy related to impacts on the healthcare industry. So it's important that we understand that the Agency of Human Services has significant role to play in health data. And so they would join that council and provide their expertise. Mr. President, that is our proposal amendment. I will say this, I know there's been a lot of discussion around a private right of action, and we're going to hear that debate. There's no question about it. We do have consumer protection in our state, and I think it's really critical as we're acting on this that we include this underlying consumer protection provision. This is what Washington State has done. I have not heard any egregious activities going on in Washington State. We have heard from Illinois, and they're backing off on what they've done. This is not Illinois. This is something different. This is what Vermont would do. We want to protect Vermonters who have a right to keeping their personal data personal. Oh, Mr. President, on that note, I will ask for the Senate's support of this proposed amendment.
Senator from Chittenden Southeast.
Thank you, Mr. President. Our committee has not seen this amendment until now, so either now or after others comment on this amendment, our committee would request a brief recess. So I suppose I am requesting that.
We'll take a recess till the fall of the gavel.
So I would like to.
Senator from Chittenden Southeast.
Thank you. I understand the senator has indicated what she has said. I did want to share that I have sent this proposed amendment when we completed it to both the Judiciary Committee Chair as well as to the Chair of Economic Development. I didn't want anyone to think I was trying to sneak something under the door, which I'm not. I think this is really important that we all know we're working together. We want to do what's right for this chamber and for the state. Thank you, Mr. President.
So I was going to declare a recess without objection, but if we're debating it, we could have a vote. So the question, so normally I would just declare a recess, and I think I will do that for the committee to have a chance. We'll have a recess till the fall of the gavel. Yep, she's setting us up. Senator, please come to order.
Yeah.
Pending question at the moment is, shall the report of the Committee on Economic Development, Housing and General Affairs be amended as offered by the Senator from Chittenden Southeast and others? And I just want to point out, and this is really more clerical, the wording of the motion on the handout is a little bit inaccurate. But the technical meaning of it is that it is an amendment to the report of the Committee on Economic Development, Housing and General Affairs. That's the question. Senator from Chittenden Southeast.
Thank you, Mr. President. I still remain concerned that we haven't adopted the report to amend this to. But I can let that go if procedurally we're still in the correct place.
So whenever a report is offered, amendments can be made to the report before it is adopted, and that is the current status of things. No
So
problem.
much.
That's my job, is to try to clear up things. I don't know that I always do it well, but here you go.
Yes. And I deeply, deeply respect the senior senator from Chittenden Southeast. I am not sure Senate Judiciary will be speaking to this piece as well. I know our committee did invite the senior senator from Chittenden Southeast to come in and present this. With our limited time to consider it, I think we still understand all of the issues that play here. I would say that a majority of us, although we didn't take any more nuanced votes, would want to honor and respect the jurisdiction of the committee as it relates to pieces that are specifically about health data and health care. And we would probably view it as friendly to add those pieces to our amendment at third reading. Those are some of the definitions, some of the HIPAA-related exemptions, that language, as well as potentially changing the study so that we're clearer about health data in our study of how to implement a private right of action. The concerns of our committee were two. On page 2 of the amendment that you find, this puts depictions, images, descriptions, or recording back in the general definition of biometric data. Our underlying bill has that included, but as it's related to specifically identifying an individual for purposes that aren't covered under the bill, I know people want to feel icky about their facial recognition data being used to identify them, et cetera. I will say that if you're using Clearview as an example, most of what Clearview does is as it relates to federal or state investigations of crime. So that kind of investigation would already be exempted from this bill as pertaining to law enforcement or government. So we carefully crafted the biometric data piece as it relates to depictions and recordings, specifically so that it was when it is not being used for a specific person to identify an individual. Given that, the House actually changed this language too to mirror ours in our underlying bill because they heard the same concern. This inclusion does not exist in any other state of the blanket biometric data, depictions, images, descriptions, or recordings, because that would probably bring in just about everything we do on the internet. Certainly you'd still have to meet the threshold, but our nonprofits that take pictures, could be sued. Any organization that has depictions, images, or recordings would fall under this now, instead of those used to identify someone that's not law enforcement using that identification system. So the House has gone along with our change. This is not a definition of biometric data that exists elsewhere. It would create huge issues, and we would oppose that. We also, on a majority vote, don't approve of a private right of action at this time. If you look at it, your Senate Health and Welfare Committee included further exemption for their healthcare entities. In the section they want to include that is any organization that falls under HIPAA regulation. but at the same time have this private right of action that would apply to sensitive data and biometric data, which generally becomes outside of the scope of one committee, and I would argue impacts all of our committees. When you are talking about sensitive and biometric data, you do get deeply into what's going on in Illinois with their Biometric Information Privacy Act, BIPA. When you look at what's happening in Illinois, most of the entities sued related to biometric data are nursing homes, school districts, manufacturers. It captures nonprofits, healthcare organizations, anyone who uses ID badges, anyone who uses fingerprints for security or sensitive information. That is a majority of who has been sued in that state. They've had over 1,500 suits brought in the last decade, 200 suits that have ended up in court. Several have gone to the Supreme Court, and the Supreme Court has now advised the Illinois legislature that they no longer want to be in the business of making law for the legislature, that the class action component of that, of what's allowed under BIPA has had an annihilating effect on some of their nonprofits and businesses. So that is the information that we brought to Senate Judiciary, because I think we need to take a much more careful look at when a private right of action is the right tool and how we use it. I just want to point out, as it relates to consumer protection, our committee looks at this issue all the time. We have a different standard and threshold and penalty for a private right of action, whether we're talking about robocalls or propane. We don't have one for data brokers. We'd be putting one specifically in for data privacy when this whole law would be new. And many of its provisions go far beyond Connecticut, far beyond other states. This is not just in my mind a Senate Judiciary question, but it's a Senate appropriations question, because other states have seen that this would add significant cost to entities that we regulate and that we fund. So the responsible thing to do, and in fact, because the PRA, even as the House passed it, is pushed out past when this study would come back, the responsible thing to do is know what we're doing before we do it, put simply. So on a vote of 3-2, and I would say reasonable people can disagree on this, but on a vote of 3-2, we oppose specifically those two changes. And I will say, as the chair, I'm very open to putting the other changes into our proposal of amendment for third reading that would incorporate the kids code into the bill. You can stop me if this is inappropriate to say, but it is very likely that with the private right of action included, we would not get a rule suspension, and both bills would probably not make it this session. Thank you, Mr. President.
I will call on you in just a moment, Senator. I just want to clarify the words bill have been used in some of the debate, and I want to make sure folks recognize you sort of have three things you can reference. There is a bill, which is the House version. There is a report, which is the Committee on Economic Development, Housing and General Affairs, and there is an amendment being offered. And sometimes some of those words get confused, I think, particularly between the report and the bill. It might be helpful for people to be cognizant of that as you discuss as you have your discussion. Senator from Chittenden Southeast, and then I'll be recognizing, just so people are aware, the senator from Bennington does have his hand up as well.
Thank you, Mr. President. I would like to indicate that it was important for us to meet in the cloakroom, since the senator from Chittenden Southeast had indicated that she hadn't seen this proposal before. So it was good to have them look at it. I would have been happy to go into that committee as well as to judiciary with an invitation. Perhaps the invitation somehow was mislaid, and for that, that's unfortunate, because we may have resolved some of the concerns that we're seeing at this time. I would like to share with folks very briefly the requirements that exist in the Health Insurance Patient Portability Act, known as HIPAA, and what is required of folks in the healthcare environment, and that might also inform how some of our other organizations might function. So first of all, HIPAA-covered entities must issue a notice of privacy practices to all patients regarding how data is protected. They must obtain patient authorization for the uses of data. They must limit the use of data to the minimum necessary. They provide employee training regarding HIPAA privacy requirements. application of HIPAA requirements to business associates and of HIPAA-covered entities. In other words, there's a continuing effort to apply that and to provide information to their business associates and others. They also provide there are HIPAA requirements or limits on disclosures to online tracking technologies on websites or mobile apps. That's really important. Mobile apps today cover your whole life. You can have a mobile app that indicates when your next menstrual period is happening. And if your employer sees that you're pregnant or you're not having a period, then you may be subject to action. And then also there's enforcement for non-compliance. So within HIPAA itself, there's enforcement. And there's also a breach of notification requirements. So HIPAA serves as a model, I think, for many other organizations in our state. I won't go further, Mr. President, but all to say, I think the work that we've done in our area is very important, and there are a lot of nuance to what's in the bill. So I look forward to the discussion, Mr. President.
Senator from Bennington.
Mr. President, the Judiciary Committee looked specifically, I believe it's the fourth instance of amendment, private right of act. And we did not come to a conclusion. Time was short, we had 45 minutes. We heard from the senator from Chittenden South, the chair of the Economic Development and Foreign Affairs. We heard from the attorney general and legislative council. And I must say, I'm a bit confused. And particularly the information about the problems in Illinois. I, as one member of the Senate Judiciary Committee, will be voting against that private right of action. And rather favor the study that is going to be proposed, I believe, at third reading by the Economic Development Committee. Pretty difficult because so many issues affect so many committees. And this certainly is within the Senate Judiciary Committee's purview. But the time to adequately vet the proposal is long past for us to discuss. So I would hope that the Judiciary Committee members are obviously on their own. But I would hope that we would do this with caution. When we sit in the judiciary, we're frequently deciding what crimes and what people, what crimes should be punished by certain sentences. We spend a lot of time talking about private rights of action and how those lawsuits against individuals will affect our state. And we want to make sure that we don't have unintended consequences. I'm sure that if we go ahead and approve this now, we will have unintended consequences in the private right of action. I'm particularly concerned about trolls in other states who just look at certain situations to find class action or other types of lawsuits. Not as concerned about the monitoring in that regard. For those reasons, I will oppose that section and hope that the section on private right of action can be voted on separately.
So are you asking to divide the question, Senator?
Right.
And that would be the fourth instance of amendment would be voted on separately, and would you care to have that vote be the first vote, or would you care to vote on the first three sections first?
Doesn't matter, the first three sections is fine. Have I got the right section? Just to make sure.
My understanding is the fourth section is the one that is the Enforcement Attorney General's powers and private right of action. And that
Yeah,
starts,
that's correct.
okay.
Thank you, Mr. President.
So Senator from Washington.
Thank you, Mr. President. The private right of action has probably been the most contentious of this whole bill. We heard a lot, and it's hard. I think we all would like to give everybody the right to defend themselves and to go to court and to sue. But some of us have been around long enough to know, to remember when there was a patent troll out there and businesses would get an email and they'd say, we have looked at the product you're selling online and we think it infringes on X and X pattern, and you can settle for $25,000 now and you can get permission to keep doing your product, or we're going to take you to court and sue you for $100,000. An awful lot of businesses paid $25,000. That, I think, is the concern. Vermont's, all of our small businesses are selling on the internet. We aren't a big enough market to support them. This is a very complex bill. It requires what could be some very expensive changes to your computer programming and your listing, and you're going to have to do that. And there's a pretty good chance that some people won't get it right the first time. And there is a cure section in here. If you don't like what's happening to your data, you can tell the company, and they have time, I forget what the final time we ended up on, to cure the problem. They cannot sell your data. We've upped the threshold because as the bill came to us, it was pointed out there's a restaurant in the town. They keep information on their customers, and these are a lot of tourist customers. They're from out of state, but they send them emails. They collect the data, probably what they ate or what they drank, but they would all be brought in. And so I think, at least for me, there's still an underlying private right of action. We're just not creating one specifically for this. And I think it's to give our businesses, we're Vermont, most of our businesses are small, and a lot of the smaller ones are the ones, the craft industries, the small manufacturers, they're the ones that are doing this online. And we've got a study to look at it. But my hope at least was we would have time to put this into effect. We would have time for businesses, and it's going to take some trial and error before everyone gets this right. And we wanted to allow that amount of time for this to happen.
Senator from Addison.
Well, first, I wanted to clarify the division of the, because there are also fifth and sixth instances of amendment. So is it first, second, third, fifth, and sixth?
That is a fair question. And since I had not yet stated the question as we got into the debate, which is my fault for not making sure that was clear, my understanding is the senator from Bennington wanted the fourth instance to be taken separately. So we'll first, and as we have already been debating, we will take the first vote on the fourth instance alone. And then the next vote would be on the first through third, plus the fifth and sixth as a singular vote.
Okay, thank you for that clarification. And then I would like to speak to the fourth instance of amendment.
That's what we're debating. Correct.
Okay, perfect.
Yep.
So your Senate Health and Welfare Committee talked about this at length and tried to come up with a solution that was a middle ground solution with the private right of action. So we defined the private right of action more narrowly and require that it be processed through the Consumer Protection Act, which is an act that is on statute and has been so for many years. It does include, as was mentioned, a cure period, meaning that for 60 days, if someone claims their data has been used inappropriately, there's a period by which the business can cure it and say, I'm sorry, I didn't mean to do that, or I did mean to do it, but I'm gonna take it back now. And so there's a cure period. And then after that, the private right of action would be through the Consumer Protection Act. So as it came to us from the House, it was a much broader private right of action that included specific dollar value damages. This does not have the dollar value damages. It is just like any other suit that would be brought through the Consumer Protection Act. So it's including consumer protections for misuse of health or sensitive data as part of the Consumer Protection Act. We thought this was an appropriate compromise, that it narrows it significantly enough, and it runs it through existing law, and is something that the Vermont Attorney General's office is familiar with and has been enforcing for many years, and that this would just be another element to that. So we tried to make it narrower, less costly, and more specific, and include that time period where there could be a cure, and to make sure that it would meet some of the concerns, or dampen some of the concerns that we heard about the PRA. In general, I think we want to make sure that Vermonters are protected, that their data is protected, especially sensitive data, especially health data. And there are many bad actors out there that we're trying to protect Vermonters from. And we felt in the Health and Welfare Committee that this threaded the needle well, and that's why I hope that you'll support this amendment in total, but especially Section 4. Thank you, Mr. President.
Senator from Chittenden Southeast.
Thank you, Mr. President. If this were to pass, this would be the broadest private right of action in the country, broader than Washington and broader than Illinois. I just want to highlight for folks that the two sections that are referenced are biometric data, which begins on page 1 and still includes things like depictions, images, or recordings, which I would ask to have included in the separation alongside Section 4 without objection, because that's the other area of concern that I have as the chair and that the majority of our committee had. Before I make a more formal motion, unless you need to take that up now, I would like people to really look at what's constituted under sensitive data. I don't have page numbers on here, but it's subsection 51, maybe on the 5th or 6th page. And we wanted higher protection for sensitive data. But if that was included in the private right of action, that is their government information, their racial, anything that identifies their racial or ethnic origin or immigration status, their sexual orientation, their status as victim of a crime, financial information, including credit card number, financial account, et cetera, consumer health data, which is what Washington regulates, one of very, very many pieces that would be under subject to private right of action, that these items are not subject to anywhere else. And personal data that reveals the condition, biometric or genetic data, data from a child. Again, we prohibit the use and sale of data from a child in the kids code, and a photograph, film recording of someone in a compromised way, precise geolocation data. Many of the things we want to treat with very heightened security, and eventually we would look at what kind of private right of action would apply to those. But as the senator from Washington said, that is where it includes financial information and a lot of identifying information that people use every day to make transactions online. The instance with a restaurant is seeing thousands of customers and having financial processors that process separately their financial information for a reservation. They would still be considered the controller in that instance as a small business or as a restaurant. So even if someone wanted to sue Resy, all of the restaurants that use Resy could be, people know what that is, more popular reservation service online. All of the restaurants could fall under a private right of action. I know a lot has been discussed about period tracking and menstrual data. I use that regularly, and a majority of the apps that people use. It's now telling me I'm 22 weeks pregnant. They are from Planned Parenthood. They are for women and designed by women. They are something that people want to use and want to have access to in our state. And I just want to remind people who would be liable under this bill: nonprofits and health organizations. I have served on the board of Planned Parenthood of Northern New England. People try to sue Planned Parenthood all the time. They would not be able to sue law enforcement or a government entity that's trying to get that information. They would have a harder time suing a very big entity that hosts that app. Who they would be left to sue is Planned Parenthood or the healthcare organization that makes that app available, if they were required by some investigation to hand that information over. So I just want to remind people that this liability applies to nonprofits and healthcare organizations as well. I don't have it in front of me because I gave the copies to Judiciary, but we have a number of organizations, nonprofits in the state that oppose the PRA, including healthcare organizations, because they are exactly who have been targeted in BIPA in Illinois. Washington's PRA is much, much more narrow. Illinois is even more narrow than this. This would include all financial information people use to make transactions. And as the senator from Bennington said, to do this on the fly would have serious unintended consequences, when we just wanted to make sure that more sensitive data was actually subject to higher protection while we educate our businesses, nonprofits, and healthcare organizations about the provisions of this bill. So more formally, Mr. President, without objection, I would ask that subsection G in the first instance of amendment that references depictions, images, descriptions, or recording be added to the same vote. I wanted to do this tomorrow as third reading, so it wasn't as confusing, but if we're doing it now, to be added to section 4, the fourth instance of amendment, I should say, so that those two are taken together, because those are grave concerns that I have as chair of the committee, that a majority of our committee has. The House has even seen why we did that, and their latest draft changes that piece as well. If there are any other unintended consequences on the rest of the provisions that are in the jurisdiction of Senate Health and Welfare, we can address those at third reading in our amendment. But I do consider the rest to be somewhat friendly, and that's me making that decision, not my committee, to vote for. I would support the rest of them because they are Senate Health and Welfare's jurisdiction, but the two pieces I mentioned fall way, way beyond the scope of Senate Health and Welfare and are squarely in the jurisdiction of other committees. Thank you, Mr. President.
Just for clarification, the request you've made is not a request solely without objection. Unfortunately, that is beyond that scenario. The only way to separate G on page 2 would be to take the first instance of amendment, vote on it separately, and while doing that discussion, to then move to strike those words from within that section. We cannot merge removing a piece of one instance of amendment with another. So for the moment, it would have to just remain, the vote right now is whether or not to adopt section 4, the fourth instance of amendment, I should say, of the amendment offered by the senator from Chittenden Southeast and others. So that is still the pending question. Senator from Chittenden Central.
May I inquire of the presenter of the amendment?
The senator from Chittenden Southeast is interrogated as the proposer of the amendment.
Thank you, Mr. President. I am a little confused. My understanding, and please correct me if I'm wrong, is that the private right of action would not come into play if someone is using, say, a menstrual tracking app, or if the entity that made it is properly using that data. It would only come into action if they misuse it or sell it or do something they should not do with it, correct?
That's my understanding, yes.
Thank you.
Senator from Windsor.
Thank you, Mr. President. I'm unsure who I should be asking this question to, and perhaps it's a question for legislative counsel as well. So I'm happy to defer to the appropriate Chittenden Southeast senator. But I have a question that pertains to the current amendment, but I believe is the same definition that exists in the underlying bill.
So there's the underlying bill, there's the report, and there's the amendment. And you have the choice to ask either the reporter of the committee report, or if it's in reference to the appropriate section, or the senator who proposed the amendment.
Okay.
That's up to you.
Okay, may I inquire of the senator from Chittenden Southeast for the underlying bill?
Senator, yes, Senator Ram Hinsdale.
Thank you, Mr. President. It was said that an example of a situation where this could apply would be ID badges and fingerprints for a company's employees. I believe that's what I heard on the floor. And I just want to understand if that's accurate, because I read the definition and it's in the amendment, and I believe it's in the underlying bill. But from my understanding, the definition of a consumer who this is under would not be an employee. But perhaps I misunderstood.
Mr. President, this, you want me to call?
You can answer, no.
This could easily apply to an employee, or for example, the ski area association came in and talked about what I call the Costco situation, but using some level of fuzzy facial recognition to ID people as having a legitimate membership or access to your facilities. So many of our ski areas use general facial recognition to give people ease, and they use the recognition of someone's tag on their coat to give someone ease to access the full ski mountain without having to continue to show their ID or try to further police who is on their ski mountain and has paid for access to that.
And if I was a ski resort, I could avoid concern by having a policy, like, because what I see for the definition of consent, that could be a written statement. So if I was a ski resort, if I got written consent, that would apply to me and I would be able to use that technology.
So thank you for asking that question, Mr. President, because I think this addresses something that the Senator from Chittenden Central asked as well. A private right of action isn't managed by anyone. It's been said that, the Attorney General knows how to manage the Consumer Protection Act. I would generally agree. It has been on the books for half a century, but the private right of action there is no one that has discretion over that private right of action than the person who believes they were wronged, the attorney that they may seek as counsel, a attorney who takes it upon themselves to find people who might be wronged by one of these provisions, and the will or discretion of a judge as to whether or not to hear a case far enough into detail to understand or know if it is a frivolous lawsuit or not. Many cases don't get to the stage of actually going to court, as has been referenced by the Senator from Bennington and the Senator from Washington. There are attorneys and law firms out there that will make threats about going to court to extort a certain dollar amount from a nonprofit, a healthcare organization, or a business entity. And that amount of money goes up every time they stand their ground as a covered entity and say, no, I know I'm not doing anything wrong. I'll wait for my day in court. They can say, we want $25,000 to $50,000 to $75,000 up until, something goes to court and they've really expended a lot of funds on an attorney anyway. That's exactly what we heard from the Vermont Country Store in the context of California's labeling law, over $2,000 worth of licorice.
Thank you. I appreciate that point. But I'm just trying to understand the language. So I understand the point that you're making is a hypothetical future lawsuit that someone could bring against an entity that is covered under this bill. What I'm reading in the language is that, and perhaps I'm being too literal, but it seems like that would be a pretty easy, well, obviously we're complying with the law because we've gotten a written statement of consent if they were to do that. And if I was a ski resort, I would go, wow, someone is trying to extort money from me, rather than we've done something wrong. So I guess I don't want to debate a hypothetical future lawsuit on the floor, but just by my reading, I feel comfortable because it seems like you would just need to have written consent. But I did just want to go back to my original question because I feel like I still don't have an answer, and I'm happy to wait for third reading if it's something we should confirm with legislative council. But based on the definition we have of a consumer, me having an ID badge for my employees is not an example of this. Or a fingerprint because they're an employee.
Mr. President, is that a question?
Yes, that is a
Okay.
question.
So first of all, Mr. President, nothing I have said is hypothetical. These are real life situations that are either happen to Vermont businesses or were the subject of court cases in Illinois, the only other state that has a private right of action. So what I would say is that we have heard from many businesses about a legitimate fear and nonprofits and healthcare organizations. They have all come in and opposed the private right of action because of a legitimate fear of being taken to court and expending thousands of dollars for legal counsel and for fees that are desired to be extracted by another law firm, usually out of state. Those are scenarios that have happened here or in other states. None of them are hypothetical. Many of the cases that went to court in Illinois under BIPA had to do with employees. In fact, the most recent Supreme Court case was around using fingerprinting technology for nurses and healthcare workers.
Yeah, if I could just pause for you. So on that point, but our definition of consumer, I think that's where my confusion is. Our definition of consumer excludes employees. So that's where I'm having trouble. Is that true? Or am I misunderstanding it?
Mr. President,
I'm happy to wait till third reading to get confirmation because that's where.
I could ask for a recess, or I could just ask the member to point out where they see the exclusion of
Yes, so
employees.
I see it if it's easiest for folks to flip to the amendment, because that's just kind of the most easy document. It's the back page of the first page under B. Under
B?
consumer. Consumer means an individual who is a resident of the state, and then B, consumer does not include an individual acting in commercial or an employment context, so on and so forth.
Mr. President, that can include some employees. In most of the scenarios that I was highlighting, this definition would have still been in place, but they can say that it's still a violation of their right because they weren't properly notified of the use of their biometric data, for example. Even if they are notified or they are considered exempt as an employee, they still have the right to bring a private right of action and let the court of jurisdiction decide whether or not it's considered frivolous or not. In Illinois, under the same context, fingerprinting was used to access high-level pharmaceuticals that people were worried about theft and misuse. And healthcare workers came to the Supreme Court with a court case around that. And the upshot of that was last year, healthcare workers were exempt from the Biometric Information Privacy Act in Illinois. They now have no privacy protection. So I think the issue at hand is how the private right of action would be used and whether it's more prudent to let a committee and an advisory group look at how this applies and how it doesn't apply. But nothing, I would say, and the senator from Bennington could answer better than I can, but nothing prohibits an individual or an attorney representing individuals from seeking redress in the court, regardless of the definitions that we put into place.
That's definitely a statement in general about how we have court cases. Yes, that people can certainly bring court cases if they feel that they are in a situation where their rights have been violated. I do agree with that. But I guess I'm in deep, and
Are you
I'll
done
perhaps
asking?
ask. I will ask for.
Are you finished inquiring?
Yes, thank you to the member from the senator from Chittenden Southeast. I would, I'll find legislative counsel before third reading because now I'm confused about the definition we have both in the amendment and in the underlying bill, and I'd love clarity because it would help inform my vote. Thank you.
So to be clear, the question is, shall the report of the Committee on Economic Development, Housing and General Affairs be amended as offered by the senator from Chittenden Southeast and others in the fourth instance and only the fourth instance of amendment. Senator from Madison.
Thank you, Mr. President. I was interested in that exchange, and I just want to reiterate that this private right of action would be through the Consumer Protection Act, which means that you have to be a consumer, and that it would also, the Attorney General has the sole enforcement. If you look on the bottom of, in the fourth instance of amendment, in the first paragraph A, the Attorney General shall have the exclusive authority to enforce such violations. And that first there must be a cure, and it must meet the provisions of the Consumer Protection Act. And as our definition does say, if you're an employee, you're not a consumer. And I think it's the point that the senator from Chittenden Central was making is an important one, that just because somebody is using your data does not mean they're using your data improperly. If they have your permission, or if they're using it in a way that is under a covered entity. For example, under HIPAA, healthcare providers use our data all the time, and they do so under the confines of very secure and comprehensive federal law that protects health data. And one of the things that your Committee on Health and Welfare did was to try to thread that needle on entities that are acting in dual means, the hybrid entities, which are actually defined under HIPAA. So I think it's really important. We've heard a lot of sort of scenarios that are not based on a violation, but are based on a possible violation. If people and entities are acting with integrity and following the law, using our data, they are allowed to do that under this provision. It's just if they don't do it well, that's when somebody, or if they violate the law, that's when somebody can bring a suit, and then it would be determined by the Attorney General if it's a violation of the Consumer Protection Act. Thank you, Mr. President.
Senator from Bennington.
Mr. President, I want to make clear what happens when somebody's sued. I was sued several years ago related to my job at the program in Bennington. And our insurance company decided we weren't covered for that particular suit. So we were on our own. It cost us approximately $25,000 to defend ourselves. And the jury was out for 7 minutes and found us not liable. 7 minutes. So that, was clearly a lawsuit that shouldn't have gone forward. Secondly, there was a business in Bennington that made snowshoes, small upstart business. And they finished some advertising online. And they didn't follow exactly the Braille instructions. And they were sued and almost put out of business by some firm from Florida who sent one of those letters that the senator from Washington was talking about. This is my concern with this section of the bill. And so I would ask when the vote be taken by roll.
Senator from Bennington has requested when the vote is taken, it be taken by roll. Question is, Senator from Chittenden Southeast.
Thank you, Mr. President. With respect to the senator from Addison, and we can take a brief recess to discuss this further, I believe she is misreading the various subsections of what exists that the Attorney General may enforce and the separate private right of action. By definition, the Attorney General does not have the authority to determine whether or not a private right of action can move forward. The Attorney General's powers is when a violation is brought to her attention. She may, in her discretion, to decide to employ a cure period before moving forward with action on behalf of the state. But the Attorney General only has the power to enforce violations under the Consumer Protection Act on behalf of the state. If someone is acting on behalf of individuals they believe were wronged or themselves, that is by definition a private right of action that, as the senator from Bennington discussed, is a judiciary matter where the question really is, can frivolous lawsuits move forward that can extort people for money regardless of any legal action taken? That entire transactional process would operate completely separate from the Attorney General's office.
Senator from Chittenden Southeast.
And for clarity, in the case of the snowshoe, as probably a cure time would allow for correction so that it would not go forward. That would, I would have to ask the Attorney General that question. I will say we're in a bit of a pickle here, a little mix around what's best for consumers, what's best for business. And we understand that. We are all in a state of wanting to help our consumers. We've seen too much going on across the country that really violates our personal rights through our personal data being exploited. That it's inappropriate and it must stop. And so I will ask the question of the reporter of the underlying bill, a question, if I might.
Senator from Chittenden Southeast is interrogated as the reporter of the amendment.
So certainly, as we talk about the private right of action, one of the considerations we're giving is to business, and we continue to think about Vermont businesses. We continue to think about small businesses versus the great big tech corporations or out there, or the business from Florida that's exploiting our people. So my question is, has the committee considered the segregation of a business size that's larger? And I think right now it's 25,000. Have you considered a business size larger that might be more apt to be subject to a private right of action versus those smaller businesses that might need time to put in place some of the conditions that I indicated earlier are already in place in HIPAA?
Thank you, Mr. President. We did take that into consideration, and I would say a few things. Number one, this doesn't just apply to businesses, it applies to nonprofits and healthcare organizations, YMCA, Boys and Girls Club, a lot of organizations that we know care about fund and have both a state presence and a national presence. Our kids code, as folks may remember, and you'll see it again tomorrow, has a very, very high threshold because it's specifically to target social media companies that operate at the highest level, essentially internationally, TikTok, Meta, et cetera. We looked at that kind of threshold in this bill. And one of the things that was pointed out to us, Mr. President, is that would in many contexts help Amazon and still hurt our small businesses. Small businesses do use targeted advertising on our largest platforms in the country to reach the most eyes. I would be very open to looking at the appropriate threshold in the future through this study, but Amazon doesn't work that way. They have their own way of sucking you in that has nothing to do with targeted advertising on other websites. They are embedded everywhere in the internet. And instead, there could be very likely geofencing that would keep small businesses in Vermont from accessing that targeted advertising platform on another large social media site if they were falling under a potential private right of action. Furthermore, we landed at 25,000 users as a way to honor the desire of the House to, as it was communicated to me by the chair of House Commerce last night, get to zero eventually. We want people to comply. without hanging a private right of action over their head. Currently, New Hampshire and Delaware have a threshold of, I believe, 35,000 consumers in their state that triggers the need to comply. And we thought we're about 2/3 of at least, roughly those states. So we would go to 25,000, the lowest threshold in the country, because we want compliance and we don't want the threat of a private right of action hanging over people's head in order to do that. So that's where we landed in this bill, and we're very open to further changes, but it's best left to people who can understand all the consequences. And as I've said to many committees, I'm not as worried about who came in to ask for an exemption or to tell us their particular unique interest in the bill. I'm worried about who doesn't even know we're doing this.
Thank you, Mr. President. I think we have the response about the numbers and the size of business. Thank you. But the PRA that is here is something that we have tried to narrow very much, in particular around consumer health data. So if it's Planned Parenthood is a clinic, and that data would be protected under this bill, as would their apps. But there are others that would not be. So, Mr. President, your Committee on Health and Welfare feels very strongly about having at least a majority of us on the committee feel strongly about having some protection for consumers and that their data is not used without consent inappropriately. Thank you, Mr. President.
Senator from Essex.
Thank you, Mr. President. I just want to remind the Senate that Vermont businesses are consumers as well. And it seems to be that a lot of what we're trying to protect are the good folks that do everything that they can do to support local economies and everybody and try to operate in a great way. And I just don't want to get lost in this discussion that there are a bunch of people who are out just to harm Vermonters, because again, the Vermont businesses are consumers, and I think that they do everything they can do to protect the people of the state. Thank you, Mr. President.
Senator from Chittenden North.
May I inquire the senior senator from?
The senator who presented the amendment is interrogated.
Mr. President, may I ask if you took testimony from the Attorney General about the private right of action?
Yes, we did. In fact, and the Attorney General suggested that we put in the underlying consumer protection statute that currently exists. I think it's 945-23, something like that. We put it into our proposed amendment.
Question is, shall the report of the Committee on Housing, General Affairs, Economic Development, and Housing General Affairs be amended as offered by the senator from Chittenden Southeast and others in the fourth instance only? Are you ready for the question? I know there's a roll call. I understand there's a roll call. I didn't ask for the ayes. I was just looking around because it's been a long debate. Want to make sure everybody had a chance. If so, Secretary shall commence to call the roll. But thank you. Do you have a point of information?
Yes, thank you. Would you be kind enough to restate the question?
The question is, shall the report of the Committee on Economic Development, Housing, and General Affairs be amended as offered by the senator from Chittenden and others, that's the handout, in the fourth instance only? That's the question.
Yeah, right. And my clarifying point is that the senator from Bennington has asked us to vote on removing the fourth instance of amendments. Is that correct?
That is not correct.
Okay, sorry.
The question was divided.
Right.
And once it is divided, you then vote on the different sections based on how they've been divided. The question would still be whether they then are affirmatively taken or not.
Okay, thank you. That's why this needs to be clarified. So we're voting on the entire amendment now, or just on the amendment as it pertains to the fourth instance?
We are voting on the fourth instance only.
Sorry.
So to be clear, in case there is any further confusion, a yes vote would mean that you would be including the Fourth Amendment into the report of the Economic Development, Housing and General Affairs report. A no vote would mean you would not be including it. The Secretary shall commence call the roll.
Senator Ruth,
Yes.
Senator Bray,
No.
Senator Brock,
No.
Senator Campion,
No.
Senator Chittenden. No. Senator Clarkson,
Yes.
Senator Collmore,
No.
Senator Cummings,
No.
Senator Hewlett,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim, No. Senator Ingle,
No.
Senator Kitchell,
No.
Senator Lyons,
Yes.
Senator McDonald,
Yes.
Senator McCormick,
Yes.
Senator Norris,
No.
Senator Perschlick,
Yes.
Senator Ron Hinsdale,
No.
Senator Sears, No. Senator Starr,
No.
Senator Bihowski,
Yes.
Senator Watson,
Yes.
Senator Weeks,
No.
Senator Westman,
No.
Senator White,
Yes.
Senator Williams,
No.
Senator Renner,
Yes.
Please listen to the results of your votes. Those voting yea, 13, those voting nay, 16, and you have failed to include the fourth instance of amendment as offered by the senator from Chittenden Southeast. Current question now is, shall the report of the Committee on Economic Development, Housing and General Affairs be amended as offered by the senator from Chittenden Southeast in the first, second, third, fifth, and sixth instances of amendment? Are you ready for that question? Senator from Chittenden Southeast.
Thank you, Mr. President. I very much appreciated that debate. And I would ask that the subsection G in the first instance of amendment also be voted on separately, and your Economic Development, Housing and General Affairs Committee, as a majority, would ask that you also vote no on this section. It has major national security implications and very broad-reaching implications for who is liable under the entire bill.
Senator from Chittenden Southeast, I am informed that the proper procedure to execute the action you would like to do is to further divide the question, to take the first instance separately, and then to offer to amend that by taking that section out. Is that what you would care to do?
That is what I would deeply desire to do, Mr. President. Thank you.
So the senator from Chittenden Southeast has requested we divide the question, and it is divisible, and take it in the first instance first, and now is offering to an amendment to remove G, which is found on page 2, and I would imagine probably by re-lettering the remainder of that section appropriately. Unless I'm incorrect, you don't have to.
I would just clarify, Mr. President, that I'm sure we could show people what that looks like on third reading while taking this action now. So yes, that is the question I'm asking. And people would see the change tomorrow.
So is the motion clear? If not, we would have to take a pause in order to present that in writing. Is the no to pause or the no to clear? So would Senator from Chittenden Central.
Thank you, Mr. President. I believe, speaking for myself, that the motion is clear, and I am happy to vote on it, but I would leave it without objection, I suppose.
Without objection, we'll proceed. And the question is there an objection? Okay, so the motion, the amendment has now been divided. We are now taking the first instance. And the motion is to strike section G, or capital letter G at the top of the second page. And relettering the H as a G. And I believe technically at the end of F, there would be the word and, because G had the word and instead that would now be F, which would have the and, just to be explicitly clear. So if you're looking at your piece of paper, turn the semicolon at the end of F into a comma and put the word and then strike depictions, images, descriptions, or recordings and strike the letter H. And that would then read G, data derived from any data in subdivision. John, can you look at that?
Points of information.
So in further investigation, as I was reading out loud, you've all noted that H has a reference to G. So would you be also moving to strike H, or would you like to take a brief recess to meet with council to see what it is you'd exactly like to do?
Mr. President, I have a third option, which is to strike the first instance of amendment in its entirety and work with your Chair of Senate Health and Welfare to put back in her sections of jurisdiction for third reading and remove subsection G at that time.
Right, so essentially by dividing the question, you're allowing that vote to happen. So by taking the first instance separately, that's exactly what you would be doing.
So we wouldn't be further dividing the first instance.
Correct, you would just vote the first instance up or down.
Yes, and may I speak?
That is the current, the
motion?
motion on the floor would be,
Thank
shall the report of the Committee on Economic Development, Housing and General Affairs be amended as offered by the senator from Chittenden Southeast in the first instance only? Senator.
I just want to clarify that in our underlying report now, the report that we're discussing, depictions, images, descriptions, or recordings does exist as a classification of sensitive data. And it exists when those depictions, images, descriptions, or recordings are used to identify a person individually that is not covered by a law enforcement investigation or other matters that have an exemption here. So we would ask your Senate Economic Development, Housing and General Affairs Committee would ask that you vote no on the first instance of amendment today. And my intent is to work to put back in any definitions that were changed that support the other work of the other instances of amendment. But for now to strike that instance of amendment because the change to where depictions, images, descriptions, or recordings is placed is it would create an extremely broad category for what biometric data is that does not exist in any other state. Thank you, Mr. President.
And by striking the whole first instance of amendment, we would be eliminating the hybrid entity for HIPAA-covered folks. And the definition of publicly available information. And removing the definition of abortion, which is probably less significant, but we would be changing the concept that we tried to put together in our committee, that there are hybrid entities that have healthcare data, and there are other that is already protected under HIPAA. And then there are other sections of data for those hybrid entities that are not covered by HIPAA and that should be subject to this legislation. So striking this section is a big concern for your Senate Health and Welfare Committee. Thank you, Mr. President.
Question is, shall the report of the Committee on Economic Development, Housing and General Affairs be amended? Senator from Madison.
Right, on a point of information, please. If we were to strike this section and pending a proposal by third reading to reproduce substantially similar but somewhat modified language, we don't have our own policies not to negate an action taken. Right.
Senator, that is a fair question to ask. Given the, if it has different language, which I presumably by the conversation it would be a different amendment and would be allowed, given that it seems as though some of these sections that would not be included apparently have importance, and being important means they would be substantially different were they not in it. Question is, shall the report of the Committee on Economic Development, Housing and General Affairs be amended as offered by the senator from Chittenden Southeast and others in the first instance only? A yes means you would include it in the report. A no means you would not be including it in the report. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The nays appear to have it.
Division?
Division's been requested. All those in favor, please indicate by standing up. You can be seated. All those opposed, please rise and remain standing. Okay. Senator Sears, can I confirm that your hand being up means you are opposed?
Yes, I am opposed.
You may be seated. Please listen to the results of your vote. Those voting aye, 14, those voting nay, 15, and you have not amended the report of the Committee on Economic Development, Housing and General Affairs as offered by the Senator from Chittenden Southeast. Question now is, shall the report of the Committee on Economic Development, Housing and General Affairs be amended as offered by the Senator from Chittenden Southeast and others in the second, third, fifth, and sixth instances? Are you ready for the question? Senator from Chittenden Southeast.
In case it's unclear, as the reporter of the underlying report, our committee is okay with these sections, and we'll look at details before third reading if there's something that creates conflict, and we will revisit section 1 and the new definitions created. But I plan on voting yes on this instance of amendment.
Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have amended the report of the Committee on Economic Development, Housing and General Affairs as offered by the Senator from Chittenden Southeast and others in the second, third, fifth, and sixth instances. Now, the question is, shall the bill be amended as offered? Excuse me, shall the Senate adopt the report of the Committee on Economic Development, Housing and General Affairs as amended? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have adopted the report of the Committee on Economic Development, Housing and General Affairs as amended. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of H 121. Senator from Chittenden Central.
Thank you, Mr. President. We are past the noon hour, and that was an important debate, but it did consume the morning session. So I want senators to be aware that we will, in all likelihood, have 3 sessions today rather than 2. So we will, I will make the motion to adjourn now until 1 p.m. pending announcements. We will come back at 1 p.m. We will try to work for a couple of hours, allow time between 3 and let's say 4, come back for a third session. That session, I'm not sure how long it will be, but senators should prepare for a long night because we have a lot on the calendar that we have not made progress on this morning. Thank you very much.
Are there any announcements? Senator from Washington.
Thank you, Mr. President. Ask the Finance Committee to grab their lunch and come down. We have at least one amendment on H 887 to go through. And I'd like to knock out our last 7 bills today, and we're going to be in a very compressed time schedule.
Senator from Bennington.
Thank you, Mr. President. Senate Education will be at 3 o'clock, if that's to be adjourned for the second.
Are there any other announcements? Senator from Essex.
Thank you, Mr. President. The Senate Institutions Committee Conference will meet at 12:30.
Are there any further announcements? Seeing none, the Senator from Chittenden Central has moved that the Senate stand adjourned until 1 p.m. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and the Senate will stand adjourned until 1 p.m.